Well, Mike,
Hey, Lou.
we're we're live, kind of.
Don't lie to the audience, Lou. It's
we,
qualifiedly a bad idea.
yeah. Well, I think that the message of today is more important than this illusion of truth of being live or recorded. What do you think?
I think that's fair. I think that's usually the case with our show, Lou.
Yeah, let's not get caught up in these details because um, what is it? The truth should never stand in the way of a good story. That
That
probably applies something,
that's
right?
that's a nostrum I'm familiar with.
Yeah, awesome. Well, we're going to get to a little bit of a faster start here because even when we do have one guest, it feels super awkward to leave them sitting in the lurch awkwardly. Now we have two. So we're going to get to introduce them here in a moment. But how about I screw up the start of the show, Mike?
Your streak is intact.
Here we go. We kind of did it. Oh, and then somehow I lost Mike's screen. I don't know if he's making a political statement there or not. But welcome to Hot Lou Happy Hour. I am your host, Lou Abramowski, or somewhat defendingly known as Hot Lou.
I am prosecutorial novice Mike Franklin.
And we're super excited today because we've got a couple of amazing guests from the Institute for Justice, which you can learn a ton about at ij.org. And they're specifically here to talk about the project on immunity and accountability. And as it relates to what everybody is talking about right now is just what are we going to do about police reform in the shadow of just another horrific event that got shared around the world and has been seen by just about everybody. But our two guests here today are Anya Bidwell and Patrick Jaicomo. Welcome to the show.
Thanks for having us.
Yeah.
I'm always impressed and intimidated when we're joined by actual lawyers. So as the audience knows, I do have a law degree. I did pass the bar. I am licensed to practice. I do mindlessly sit through CLEs, but you guys are going to school me. So
I guess the question is, do you know where your bar card is right now?
I do actually. Yeah, I have it, and I keep it because it's a reminder of how much I paid for it.
Yeah, then you have to be in the top 25% then.
Yeah, and full disclosure here, Mike and I have actually been invited to at least one TV court drama show. Yeah, we declined. Yeah, we declined. But okay, let's dive into this whole thing. I'm going to give my super novice explanation to this, and hopefully that will maybe help the Lounatics, our audience here, kind of roughly understand what we're about to talk about. But as a novice here, as I understand it, this whole qualified immunity thing really, at its guts, talks about the fact that a government employee, and in this case, let's just talk about it as a police officer, is not subject to a civil lawsuit to be held accountable for their actions while on the job. And that has all kinds of issues with it, which we'll get into. But did I summarize that well, do you think, Patrick?
Yeah, I do. I mean, I think you hit one of the main points right off the bat, which is that qualified immunity applies to all government officials, whether it's local, state, or federal, not just police. And essentially, it is an immunity from suit for any civil rights or constitutional violation that an officer is accused of having committed. And essentially, the way it works is you can't sue a government official who violates your constitutional rights unless there's already a court decision by the U.S. Supreme Court or the highest court of appeals, wherever you happen to live, that specifically addresses the same particular facts and finds that they were a constitutional violation.
Yeah.
And so that makes it sound a lot more complicated than it really is, and we can drill down into it. But right off the bat, I also want to point out that qualified immunity is a doctrine that the U.S. Supreme Court just made up in 1982 in a case called Harlow versus Fitzgerald. It hadn't existed before then. The Civil Rights Act, it's usually invoked when someone is suing a government official who violated their constitutional rights, is something called Section 1983. And it's a provision of the Civil Rights Act of 1871 that was passed right after the Civil War and the ratification of the 14th Amendment. And that statute very plainly just says anybody who violates someone's rights under color of state law is liable. That's it. There's no special exception. There's nothing about qualified immunity. And so between 1871, basically 1970, there was no exception at all. When a government official violated your rights, you could sue them and the court would award damages if it found that they did in fact violate your constitutional rights.
Okay, so I am certain that there are viewers and listeners right now with their heads exploding, not understanding what purpose would this serve. So I want to talk about the problems, but obviously this exists because it did probably solve some previous problem. Can you, Anya, maybe talk a little bit about what the actual benefits are to this first, and then we can talk about all the problems kind of following it from there?
Sure, and before I talk about benefits, let me just make something clear, right? These kind of benefits considerations are purview of Congress, right? They're not purview of the judiciary. So even if you can make an argument, there are certain benefits to having certain immunity protections, for example, that's a policy determination that's supposed to be there for elected officials to make, right? Not for judges. What the job of the judiciary is to essentially look into whether the law was violated, determine whether it was violated, and then if it was, order a remedy, right? And then it is job of the legislature to calibrate incentives and to worry about certain, issues like chilling effect, for example. So just to set the background, that's the separation of powers, right? Judges do law, Congress does policy, right? And then if you're Congress, you could think about potentially calibrating incentives if you are, for example, worried that an officer who is making a split-second decision is going to be deterred from acting in his best interest, in society's best interest, because he's worried of being sued. Then as Congress, it might make sense for you to pass particular legislation to calibrate the incentives and to make sure that that officer who is making that split-second decision is protected. Of course, generally speaking, like the 8 cases before the US Supreme Court, for example, right now, none of them involve any kind of split-second type of a decision, right? And also, if you do want to calibrate incentives in such a manner that the officer feels safe, you don't necessarily just have to provide them with immunity that essentially, even though it's called qualified immunity, is now becoming absolute immunity. So, but yes, I thought there are definitely certain considerations to be made. Judges are not the right people to be making them.
Could you talk about that a little bit? I mean, I think the separation of powers principle is complicated even to lawyers. And, even having gone through law school myself, it's not always clear who's making the law at issue here. And you guys have been very explicit that in this case, it is the Supreme Court. But I had to close some windows because my computer was acting up, but I don't think it was in your article, but I've been reading, by the way, you guys did an awesome article, so how we found you in USA Today that really makes this accessible for people. But another one I read, or correct me if it was in yours, but described qualified immunity and really this whole concept of how we hold individuals responsible for justice as a Russian nesting doll. We're sort of at the smallest doll in the very middle is basically the concept that if you wrong me, I can sue you. And then sort of on the next doll is a sort of government, the principle that government actors maybe shouldn't be liable for the decisions they make and under color of their action. Then the next doll is Section 1983. And then the next doll is, it gets really complicated really quickly. So can you kind of talk a little bit about the whole, Anya did a great job there talking about, whose job it is to make law, but talk a little bit about, kind of the premise of separation of powers and maybe why that's a little warped in this instance. Either way.
I'd hate to take the Russian nesting doll analogy away from Anya, but
go ahead.
I would say first, right off, before I go through the different size dolls, I think that the reasonable officers are being excused from reasonable actions doll needs to go after the Civil Rights Act doll, because Right at the founding in 1804, the US Supreme Court had a case called Little versus Bahrain. And it's a very famous case involving the capture of a ship called the Flying Fish. And the naval captain, George Little, who captured the boat, did so on the orders of the president. And because of a weird quirk in the law that was in place during the time of war, the law only allowed the seizure of boats going to a certain country's ports and not boats coming back. And so this captain had seized one coming back in violation of the law, but pursuant to the president's order. And the owner of the ship sued the captain himself. And the US Supreme Court granted damages against the naval captain who was acting on orders of the president. And Chief Justice Marshall, just a year after they decided about judicial review in Marbury versus Madison, said, I was initially inclined in this case to be forgiving to this man's military obedience to the president and to give him an exception for being reasonable in taking this ship. But my colleagues convinced me that you can't create exceptions to the Constitution based on reasonableness. If there's a right granted under the law or the Constitution, then there is no exception to it unless the Constitution or the law provides that exception.
And then what did Congress do to the officer?
And so at the time, and for a long, long time after that, the way it would work was the Supreme Court would look at a situation, for example, this captain taking the ship, and they would say, is that a violation of the law or the Constitution? Yes, it is. So we're going to grant an appropriate remedy, which is usually damages, because normally you bring these lawsuits after the thing has happened to you, so you can't stop it. And then Congress would look at the situation and decide, yeah, this person was acting reasonably, so we're going to indemnify that person. And so that was historically what would happen, was the court would do the law, and it would say, did you violate the Constitution or the laws? Yes, okay, then you have to pay damages to the person you harmed. And then Congress would come in on the other end and say, Captain Little was reasonable, so we are going to indemnify him for those damages. And that way, the Constitution was enforced, the person who was wronged had a remedy, and the person who acted reasonably was then saved from some severe repercussions by Congress stepping in with indemnification. And that was pretty much the system, without exception, from 1804 through the first half of the 19th century. So for instance, there is a case from 1915, after the Civil Rights Act was passed, called Meyer versus Anderson, or might have been Anderson versus Myers. And basically what happened was a group of elections officials, following a state law, stopped a number of black voters from voting. And when the black voters sued them, the officials said, you can't hold us responsible. We were reasonably enforcing a law that was on the books in our state. And the Supreme Court said, no, that's not okay. If there is no constitutional basis for the law, you can't rely on it to excuse your unconstitutional actions, and you have to pay damages.
So yeah, I'm trying to put myself in the minds of our lunatics here, which we call our listeners lunatic with an emphasis on the Lou. If I'm understanding this right, it's kind of akin to you're like a sandwich artist at Subway, and you've got a store manager telling you to put like hot sauce in a sandwich that they probably shouldn't necessarily be putting hot sauce in because the customer might be like ultra sensitive to it. And then, or maybe a better way to say it is that the manager says, don't put the hot sauce in. And then the owner shows up and says, you better put hot sauce on that sandwich to damage this customer because I don't like this person. And then it puts that employee in this really tough situation on, you've got the owner telling them one thing and the manager telling them the other. And then is the customer in that situation able to like file a lawsuit against the employee or what? It sounds like that's what you're kind of an analogous situation that you're describing. Is that kind of accurate?
I mean, at the heart of it, right? At the heart of it is the question of whether a constitutional right was violated, right? And if where there is a right, there is a remedy, right? The doctrine that goes back hundreds of years. Right. At the heart of it is this person's constitutional rights were violated. The first order of priority, as far as the judiciary is concerned, is to determine whether the rights were violated, and order a remedy if they were, right? That's the concern of the judiciary. And then the concern of Congress is to calibrate the incentives in such a manner that would also protect the officer.
But let's talk sandwiches.
Finally, we started the show 2.5 months ago, and I've been begging for somebody to talk sandwiches.
So let's use the sandwich analogy. If you go into a Subway store and you tell the sandwich artist, I want a sandwich and I want these things on it, and by the way, please make sure there's no hot sauce on it because I'm definitely allergic to hot sauce, and if you give me hot sauce, I'm going to go into anaphylactic shock and have to go to the hospital and spend a bunch of money on medical bills. Okay. So you get to the end of the line, you take your sandwich and you go eat it, and it turns out it has hot sauce in it, and you go into shock and you go to the hospital and you have a bunch of bills. If you're that person, you obviously should be entitled to some sort of remedy for the wrong that was done to you, because you went in there, you bought a sandwich with no hot sauce, told them that hot sauce would hurt you, and you got hot sauce and got hurt. So from your side of the equation, it doesn't really matter who told who to put the hot sauce on or why the hot sauce got put on. Courts are supposed to look at you and say, you need to be made whole for a wrong that happened to you, and so we're going to order that. So that's the simple sandwich eating side of it. From the other side of it, the only reason it's different from the government analogy is because the owner in the sandwich shop situation, he would be vicariously liable if his employee did that. But because of a concept called sovereign immunity, the government itself is never liable. You can't sue the government unless it says you're allowed to. And so if the solution in the sandwich shop situation is just to sue the owner, you can do that directly, or you can do it vicariously by saying you're responsible for the actions of your employees when they're doing the job you paid them to do. And when your employee was doing that job, I was harmed. But in the government situation, you can't run it back upstream because the government itself can never be held liable. And that's actually one.
Unless it's a municipality, right? Like just a little asterisk. If it is a municipality, right, like a county or something, then you can sue them. But again, it is extremely difficult. It's just essentially as difficult as to overcome qualified immunity. And that kind of goes back to the concept of immunities in general.
But the reason you can sue a municipality is because of the civil rights statute. That essentially, after we waged a civil war to decide what the balance of state versus federal power would be, the federal government, after the ratification of the 14th Amendment, said we're going to enact Section 1983, and it's going to have an impact on what state officers can do. And so that's the reason why you can sue a municipality. You can't, for instance, just sue the federal government or, for other constitutional reasons, the state of Minnesota. And so historically, because there's been this special protection of the sandwich shop owner in the government context, the concept of this strict liability of the sandwich artist is to compensate for that. Because if I'm the harmed person, I get a remedy. The sandwich artist, who might have been in an impossible position and was just reasonably following orders, he can then look to his boss and say, hey, you told me to do that. You should be paying for this. And then the boss, who's ultimately should have been responsible to begin with, is the one who ends up paying the ultimate damages for the actions that he ultimately set in place for one reason or another.
So before we get into the sort of how you might apply this to the George Floyd case, your article had some really remarkable examples of where this doctrine is under test by hopefully by the Supreme Court, and you can get into that too a little bit. But could you give some of those examples and then why these are good examples of sort of qualified immunity or not being followed, or rather being followed, but to its absurd conclusion?
Yeah,
sure.
Let's share some of those examples. But before we go, I just want to point out, as Anya and I talk about these specific cases, that as you might pop into your head, you'll think, well, it can't be that an officer who intentionally violates the law gets away with it, or that an officer who's just totally incompetent gets away from the law or gets away with it, or that an officer does something that's so obviously wrong they get away with it. And none of those things are considered in qualified immunity. None of them. They don't consider whether you intentionally acted, whether you maliciously acted, whether it would have been obvious to a reasonable person that what you're doing is bad. None of that's a consideration. So with that, we can get into each of these several cases that's pending right now.
Yeah, here we were talking just now, right? We were actually talking about this employee in the sandwich shop that really didn't do anything wrong and kind of stuck between the heart and the rock and the place, whatever you say it. How does the
rock in the hard place, stuck between a rock.
Thank you, rock in the hard place. There you go. But with these kind of cases that are before the US Supreme Court right now, you really don't have that kind of a situation, right? You have a situation where it is taken as true, right, that police officers in Fresno, under a proper warrant, went and searched the house of somebody and stole $250,000, right? It is taken by the court as true, and the court basically says, the Ninth Circuit says, okay, let's see. So these guys stole $250,000. Can they be held accountable, given that they stole that money? And they say, you know what? No, because there isn't a case directly on point that specifically says that it is a violation of the Constitution to steal the money, right? Then there is another case where you have the police officers seizing a dog on a suspect who is not presenting any threat. The suspect is basically sitting down, right? And is not resisting at all. And again, taken that basically this officer did this, right? The circuit court is looking at it and says, Supreme Court case or a case within the Sixth Circuit that says that you cannot seize a dog on a suspect who is sitting down. And it says, you know what? No, there isn't. There is a case where a suspect is actually laying down on his side, right? But that's different. Laying down on his side is very different from sitting down. Therefore, the officer could have not known that what the officer was doing was unconstitutional. Therefore, the officer can get away with it.
Oh, let me do one. Let me do one.
These are insane. I mean, this is outrageous.
You can't make it up. I mean, this is a truth is stranger than fiction. So, for instance, there is a case out of the 11th Circuit where a cop who was with other cops trying to find a bad guy who wasn't even present made a bunch of little kids lay down in the yard at gunpoint. And when there was a non-threatening family dog that came around the corner of the house, he tried to shoot the dog twice. Now, he didn't hit the dog, but he did hit a 10-year-old. And the 11th Circuit said, yeah, sorry, there's no case on point that says that recklessly shooting your gun into a crowd of children for no reason and hitting one is a constitutional violation. So the officer gets qualified immunity. That's actually a case that the court's going to consider on Thursday at its conference this week. And there's a West. Oh yeah, West is an IJ case. So yeah. West is a case out of Idaho where a mom showed up at her house to find a bunch of police who were there, and she had to do something with her children, and so they said they were looking for her boyfriend who was wanted for some crime. She said he wasn't there, but she gave them her keys to enter the house and then left. And then over the course of the next 10 or 12 hours, instead of using the keys to get into the house, the police fired gas grenades through all the windows into what turned out to be a totally empty house except for her dog, Blue. And then after all was said and done, she sued and said, you violated my constitutional rights when you destroyed my entire house. And they said, well— You exceeded
the scope of consent, right? Yeah, there is and there are cases on point that specifically say that you cannot exceed the scope of consent.
And so to translate that, what the police said was, no, when you gave us your keys, you consented for us to enter your home, and that consent included us being able to fire grenades through your windows into your house. And the Ninth Circuit on appeal said, well, there's no case law that specifically says that when you tell someone they can go in your house, that doesn't include firing grenades through the windows into your house. And so, I guess be very careful if you invite anyone over from the Ninth Circuit Court of Appeals to your house for dinner, because—
just before we go on, because these are just delicious examples. It isn't to say that these officers in these cases are not subject to any kind of discipline, right? Or any kind of process. It's just to say that the victims are not allowed to sue them on a civil rights claim. Is that basically the end of it?
Yeah, so qualified immunity itself only applies to civil lawsuits against government officials. And so you've got that one prong. You've got obviously a prosecutor, as has happened to one of the officers with the George Floyd incident. A prosecutor can charge someone if they violate the law. Obviously, there's a lot of incentives there. And because prosecutors are interacting with police a lot and are themselves government officials, they're usually very reluctant to do that. So a lot of times the criminal side of it's not an issue, or maybe there's not even an actual crime. So all you have left are civil remedies, and qualified immunity applies to all of them under federal civil rights and constitutional law. Theoretically, there's also a claim you might be able to bring under various circumstances for a tort claim in a state court, but typically most states have pretty robust governmental immunity of their own that shields officers in particular from any liability under tort statutes.
Yeah, and if you are a federal officer, then there's even a greater degree of protection, right? Like, let me tell you briefly about this case, Hernandez versus Mesa. And you might have heard about it. There were actually several cases where the same fact pattern occurred, where a Customs and Border Protection officer essentially shot and killed a kid, a 15-year-old non-threatening Mexican teenager across the border, right? So prosecutors essentially declined to bring charges against the CBP officer. And because of the way the law works, you actually cannot sue a federal officer in state court for constitutional violations, right? So for parents of this dead 15-year-old teenager, the only remedy possible, the only remedy available was to actually go to a federal court, right? And basically say, we're suing you for the use of excessive force. And because of these doctrines, first qualified immunity, and then second, this doctrine called Bivens, where it was actually very hard to file a claim against a federal officer in the first place, forget qualified immunity. The parents were essentially left with no remedy whatsoever.
Oh, man.
So,
okay.
Yeah.
So I want to take a step back, and then I think maybe we can all commit to just spending 2 hours telling all of these horrifying stories, because by now I hope the listener here is thinking to themselves, what is happening? These are horrifying stories where, you know, these officers are taking what, you know, at least as we've described them, to be like just unfathomably like cruel, that there would be no individual recourse in these cases. But I want to make sure that I recap a little bit about the qualified immunity, what the brief benefits are, and then also, because we really are diving into the serious problems with it through storytelling, but I'm going to try to summarize in a little monologue here where we're at, so and do it in as simple terms as I understand them, and then just interrupt me if I screw this up. But we talked about what qualified immunity is pretty well. Yeah, that was quick. But the bottom line is, you know, effectively the defense for qualified immunity is that it's trying to really protect these government employees against the burden of litigation and the burden of potentially bankruptcy, because those two things can really deter somebody to want to hold some sort of government office. And that seems to be the bulk of the defense of why that exists.
Yeah. So I know you explicitly asked this question a little earlier, and we should dive into it. So setting aside whether the courts are the ones that should be making policy decisions, that's what they did when they created qualified immunity. And when they did it, they basically said, we're going to do this because we think that if there are all these lawsuits, first of all, it will chill the actions of police officers or other government officials, especially in difficult situations, so that they won't want to act, and that'll be a whole problem in and of itself. And second, we don't want to make it impossible to hire government officials because they think that they might get sued into bankruptcy if they simply make a mistake. And so right off the bat, the glaring problem with the second piece is that until 1967, there was no type of special defense for government officials who violated the law or constitution at all. And I don't think anyone has made a compelling argument that it was really hard to hire cops in 1966 or earlier.
I think just to be on the opposite side of that, we were probably living in a far less litigious time back then. I think that would be fair to say at that point, right?
Right, and so to come into the future instead of looking at it from the past, Professor Joanna Schwartz has done amazing work on this with her scholarship, and she's basically found that anytime you're able to hold a government official liable, whether it's through a civil rights statute or something else, 99+% of the time, the municipality or employer of the government official is the one who pays. So a very tiny, tiny fraction, a fraction of 1% of the damages that are awarded against government officials in their individual capacity are paid by those government officials. And so the concern that it would bankrupt individual officers is totally unfounded. And on the issue of chilling their conduct, Joanna Schwartz has also looked into that and basically found that there's no evidence that any of the officers that she's looked at think about these things when they're doing their job. They have their training and they have their handbook, and they may or may not try to follow it as best they can. But none of them in the back of their minds are thinking about qualified immunity, because even to them, it's a concept that's fairly obscure and not something that they're thinking about. It really only comes up after the fact when something happens and they get sued, and now there's a government attorney on their behalf raising this issue.
Okay, so now what I want to do, so hopefully people understand why it exists, and you dove into a little bit of the reasons why it shouldn't exist. I want to talk about specifically the 3 problems that we have outlined in great detail in a couple of stories already. But the big one obviously is that these, particularly police officers, are just not held accountable for their personal act. They're not personally held accountable in the context of a lawsuit. Obviously they can be fired. There's opposite ends of the spectrum there that they can remedy that on their own. But the second one that Anya, you detailed in one of your stories, specifically this the U.S. Court of Appeals in the 9th District, about these officers stealing what ended up being $275,000 in cash and property, and not being held accountable for that they could just steal property. And then the third one, which is very fascinating to me, is that, as I understand it, the Civil Rights Act of 1976 actually allows attorneys to recover the cost of representing their client in the case where in the case that they win or lose. So if somebody needs to have their civil rights defended or represented in the court, but that individual can't afford hundreds of thousands of dollars in legal costs, the Civil Rights Act of 1976 protects that. But what's interesting about that is that it actually has an exemption for qualified immunity. So in this particular case, let's say George Floyd's family wanted to sue Derek Chauvin under the for violating his civil rights for what seems to be his right to be alive. An attorney representing him wouldn't be guaranteed to be able to recover the funds, win or lose, in that case under the protection of the Civil Rights Act. And those are the 3 huge criticisms that we've kind of outlined with a couple stories, but that third one I wanted to get on. Did I get all of that right in terms of like, what are the big, huge things, Anya?
Generally speaking, you have, yes. And with the attorney's fees, it is much easier to recover attorney's fees if you sue a state officer rather than a federal officer, right? So when it comes to suing federal officers, then you're not entitled to attorney's fees either, and not entitled to attorney's fees at all. And that kind of zooms in on this very important issue, in that it is hard to be able to sue somebody for civil rights violations to begin with. There are just so many barriers, right? And Patrick and I are representing this wonderful young man, James King, before the United States Supreme Court next term. Patrick is gonna do the oral argument. And there, James always tells us, right, basically, guys, if you weren't representing me pro bono, I would have never done this. And what happened to James, he was basically 6 years ago he was a college student working from one place of work to another place of work. And this joint task force misidentified him as a fugitive, completely unreasonably, by the way, because he looked nothing like that fugitive. And by the way, the fugitive didn't really commit a very serious, like super violent crime. He just stole stuff, right? But they misidentified James, and they tackled him, and they assaulted him essentially, and beaten him up, and then arrested him, and then filed charges against him. So there's a lot of like crazy stuff going on, right? And so 6 years later, James is still not able to get the government, those officers who actually assaulted him, to file an answer in his complaint, right? It's an amazing police brutality story, but the fact of the matter is that had James not found Patrick, right, or had Patrick not found James, then James would have not really been able to sue these officers for what they did to him, right? No matter how terrible the violations were, he would have not done this if he didn't find somebody pro bono.
And this case is gone all the way up to the Supreme Court on, it's another example of qualified immunity?
It's even more outrageous. Go ahead, Patrick.
Yeah, it's even worse. And just to put a button on what Anya was saying. So when this happened to James, he was a 21-year-old college student. And as you can imagine, if you're a 21-year-old college student, you can't afford to pay what it costs to hire lawyers on an hourly basis to do anything, let alone defend you in a case that you stand a very small chance of winning because of all these special doctrines. And so a lot of these things just are never going to get remedied for that reason alone, which is in itself an injustice, because there are a lot of people that end up on the wrong side of some sort of government enforcement action, whether it be by police or in a prison or anywhere else, are not the kind of people that have $100, $200, $500,000 sitting around to handle paying lawyers by the hour for 10 years worth of litigation. And but in substance, this case started as a qualified immunity case because James got beat up. He got charged with several felonies. A prosecutor took him to trial and he was acquitted on all charges. So then we filed a civil rights lawsuit on behalf of James against these officers, saying you violated James's constitutional rights. And we also asserted tort claims under something called the Federal Tort Claims Act. And the trial court threw out James's case on qualified immunity, as is, common.
Expected, really, right?
The real shocking thing in this case was that we were able to persuade the Sixth Circuit Court of Appeals to reverse that ruling. So they overturned the holding of the district court and said, no, there actually isn't qualified immunity. You can sue these guys. And we were so excited. It had taken 4 or 5 years, but now we were finally going to be able to move forward in the litigation because, as Anya mentioned, and many of the lunatics might not know this, but typically when you file a lawsuit, you file a document called a complaint, and it just lists out this stuff happened and this is a violation of these rights and you have to do this to make me whole. And then normally the second step in that process is the other side writing something called an answer, where they go line by line through and they say, yes, that's true. No, this isn't true. We don't owe you money. That's the second step normally. Well, we've been litigating this case for 6 years and we haven't gotten to the second step.
Oh my gosh.
And so when the Sixth Circuit reversed the qualified immunity decision, they said, case goes back down, trial moves forward, you get to do discovery, they got to answer. Okay, great. Now we're finally in the courthouse. But before we could get back in the courthouse doors, the U.S. Solicitor General took the case and petitioned the U.S. Supreme Court to now create a new special protection under this thing called the Federal Tort Claims Act that would apply to all federal agents above and beyond qualified immunity. So just to recap, James got beat up. He was totally innocent, just simply unreasonably misidentified by a police officer and an FBI agent. Instead of saying sorry, they prosecuted him for felonies. He was acquitted. Then when he sued to vindicate his constitutional rights, the trial court threw it out on qualified immunity. The Sixth Circuit said no qualified immunity, case goes back down. And after all that, the government is still taking it up to the Supreme Court and asking them to create a new special protection. And the Supreme Court granted cert in the case that we're going to argue next term. So there's really no end to this shell game, and it's almost impossible to navigate it, even if you are able to find pro bono counsel who's willing to represent you for what's now been. I've been working with James since 2015 on things related to this case.
Yeah.
And to kind of add like one little thing with qualified immunity is that even if, let's say, the judge basically says, at the motion to dismiss stage, the judge says, okay, you're right, plaintiff. You're right, James, qualified immunity should not protect the police officer right now. You go back down, the police officer gets to invoke that qualified immunity again at the summary judgment stage, right? And that's all before trial. And then after the trial is over, they get to again appeal qualified immunity. So you have at least 3 bites at the apple as a police officer when it comes to qualified immunity.
This seems like it worked a lot better in 1804 when we were just dealing with presidents trying to hijack enemy warships.
It's kind of shocking. It's kind of shocking, right? That some guy who owned a foreign ship was able to get through the court process more simply than a 21-year-old college student who was just minding his own business and got beat up.
Oh man,
we're getting on towards kind of a reasonable conclusion of our time here. But one thing, and I know Lou, I'm sorry, I don't mean to Bigfoot you there, but so who on of the current 9 justices on the Supreme Court, who should we be watching when these cases are argued? Because it seems, and I can't recall again, I've been having technical issues, so I can't refer to your article, but I saw some inclination or some indication that both Justices Thomas and Sotomayor have
it's a bipartisan issue.
Had left the
it's
door
a cross
open.
ideological issue.
Thank you for calling that out, Anya, for the lunatics who aren't court watchers. It can be probably reasonably said that Clarence Thomas is furthest to the right, at least on the grounds of sort of originalism, and Justice Sotomayor is very clearly on the left when it comes to the court. Who should we be watching next week, and which of the justices might be inclined to sort of not overturn a 1982 court-created doctrine, which all 5 of the conservatives arguably should be persuaded to do just on that basis?
Well, we think we really can persuade every single one of those justices, right? Like the kind of principles that they believe in, the kind of principles that they talk about in public, the kind of principles that they write about in their opinions, they all can be squared with this very important principle of accountability. And just like you're saying, Justice Sotomayor spoke against qualified immunity. Justice Ginsburg spoke against qualified immunity. Justice Breyer spoke against qualified immunity. Justice Thomas spoke against qualified immunity. Justice Gorsuch spoke against qualified immunity. You have a lot of folks basically understanding a very, very important fundamental problems with qualified immunity. That's why we are optimistic that at some point, this issue, the court created it in 1982, and the court very much can take that back.
Yeah, and just to follow up on that, this is a truly nonpartisan issue. And so in addition to the justices, as Anya explained, the entities that are opposing qualified immunity are as politically diverse or ideologically diverse as you could possibly imagine. You've got the ACLU, you've got the Cato Institute, you have Americans for Prosperity, you have the NAACP Defense Fund, you have the Institute for Justice, you have
even National Review wrote something basically talking about this. Yeah,
so when you have the New York Times editorial board and National Review agreeing on an ideology,
we don't agree on what time it is.
Yeah, it's just this is a strange moment, and so there's really no principled defense of qualified immunity. The only thing that anyone can seem to point out is that it's existed since 1982, and I guess that should be enough.
So what exactly, if anything, and we realize that sort of going through the process of just as you described with James King, I mean, the legal system is at its very best seems hard to navigate and inaccessible. And at this case, you're literally in front of the Supreme Court. There are 9 people whose opinions on this matter. Is there anything that our audience can do, even tangentially, to help you out, to help your case out, to inform what?
Yeah, and I wouldn't even like classify it that way. Like I'll say I think Mike and I both believe in your cause, and it sounds like America believes in the cause, but I think in order to believe in the cause, you kind of have to understand it first, and then from there be able to kind of talk about it. But I'm sure heads are spinning right now as they listen to this. I put some work into understanding something that I had never even heard of 48 hours ago to try to understand it, and I'm still not following some finer details. So let's make this 2 things. So if one, maybe Anya, you could talk about how people can try to grasp really what's happening here. And then maybe Patrick, you can talk about like elevating the message and helping pursue it a little bit.
Absolutely. This is such a great point. One of the hardest classes in law school, right? And Mike, you would know this, it's federal courts, right?
Oh, yeah.
And it's all these immunities and all these different doctrines, procedural doctrines that make it really hard to be able to sue the government in the first place, right? It's a very hard law school class. And even law students have a very difficult time wrapping their head around this, right? Yeah. But I think a very good way to get started actually is by going on IJ's page for its project on immunity and accountability. There, we kind of explain everything through the perspective of the West case that Patrick briefly talked about. And once you have facts, then you can kind of really wrap around your head around the doctrines. And then if you keep scrolling down and reading that page, you will see some of the briefs that we filed in the US Supreme Court trying to explain the origins of the doctrine and trying to make the argument the best we can. So that page will be a really good resource to begin with. We are also always very happy to answer emails from, Lounatics.
I bet you never thought you'd have to utter that phrase.
I know, it's just like, say this, really?
Yeah. So Patrick, could you tell us a little bit about what, I think that's awesome, Anya, and it's super helpful. And hopefully, the people that care about this can put the level of effort into kind of understanding it.
Oh, one plug
Sure.
for Patrick. One plug
Of
for
course.
Erwin Chemerinsky. He is a dean of Berkeley Law School. And in 2016, he wrote a book intended for general public, right? He wrote a treatise on federal jurisdiction, but he also wrote a book called Closing the Courthouse Doors. And that book explains every single one of those doctrines in the most digestible way possible. So in addition to going on our website, check out his book, Closing the Courthouse Doors.
I've had to buy several of his books that are far less accessible.
Far more expensive, I'd wager.
Yeah, absolutely.
All right,
So,
we'll definitely include those links in the show notes and make them available to the audience. Sorry to cut you off there, Patrick, but what can we do to elevate this message once people kind of grasp the concept and maybe help out James King or anybody else you guys are representing?
So I think it's two prongs. It's one is do what Anya said and check out ij.org or look at our USA Today op-ed about this and just look at some of these general public consumption documents that explain what happened here. I mean, you don't need necessarily to understand the finer inner workings of legal procedure to know that there's something wrong with the fact that police can steal $225,000 and a court will say, yeah, but it wasn't clearly established that that was a violation of the Constitution, or that a cop can shoot into a crowd of kids and hit one trying to shoot a dog that's not threatening, and the court will say the same thing. And so I think you really just need to take a second and internalize that that's actually what's happening. I think a lot of the problem is that as long as this doctrine has persisted, it's been so mind-blowing that when people hear about it casually, it goes in one ear and out the other. And it's just like a word you've never learned. And so you don't hear it, and then one day you learn it, and all of a sudden you see that word all over the place.
Yeah, can I interrupt you really quickly, Patrick? Because it's something that we glossed over, and I know you guys are tight on time and you've been super generous, but we glossed over this phrase "clearly established." And as I understand it, what that really means is that if there was a previous precedent in a ruling, that's really the only way that qualified immunity gets disqualified, is if, let's say in the George Floyd case, that there was a specific case previously where a police officer put his knee on the neck of a suspect in custody and he died, and there was actually a ruling, a precedent stated in those exact terms. That's the clearly part. And then the precedent part is the established part. So if no previous court case exists and ruled in favor of that suspect whose civil rights were violated, then they're just going to follow. The police officer is going to actually be not exonerated, but not certainly held liable for those actions because it's not clearly established.
Yeah, and worse than that, then the court also doesn't have to establish precedent.
Right.
Going forward, right? Like the court actually doesn't have to, like in the theft case, the court doesn't have to say intentional stealing is a violation of the Fourth Amendment. The court basically can say, we don't see a case that specifically says stealing is a violation of the Fourth Amendment, so bye.
And they did. That's the key too. Is in Jessup, the case where the stealing took place, they explicitly did not establish a new rule. And so technically, in all the states covered by the Ninth Circuit, There's no clearly established rule that you can't steal from people while executing a search warrant if you're a cop, which means the next time it happens, the officer will still be immune.
So so this is why I wanted to come back to that. And I'm so sorry for interrupting you, Patrick, because this seems to be so important, because not only if that precedent doesn't exist, as I understand it, we're in this catch-22 that if it doesn't already exist, it will never exist, because no precedent can be set in the future. So
that's right.
Courts do have the discretion, right? If they want to, they have an opportunity to say, we feel like this is not clearly established as of this moment, but we, the court, are now saying this is a violation of a constitutional right. So going forward, hear me, this is a violation of a constitutional right. But they don't have to. They're not required.
And when they do that, it doesn't apply in that case they're deciding. So you're hopefully making law for the next person who gets their rights. And we mentioned this in the USA Today editorial, but I really want people to understand that we're not being hyperbolic when we say how specific courts are being when they're applying clearly established to decide whether qualified immunity applies. And so there's a case that was recently decided in the Fifth Circuit out of Texas, where a prison guard sprayed an inmate who was locked in his cell with pepper spray for no reason. Those are the accepted facts of the case. And the inmate, who represented himself without a lawyer, found a case, or several cases actually. One of the cases involved a prison guard who hit an inmate with a baton and did it for no reason. And the court said that's a constitutional violation. And so the inmate said, look, here's a case where a prison guard hurt someone for no reason. And they said that's a constitutional violation. And the Fifth Circuit said, yeah, but that involved a baton and you got pepper sprayed. So it's not clearly established that pepper spraying an inmate for no reason violates their constitutional rights. Qualified immunity.
I feel like John Marshall is rolling over somewhere.
We link to that case in our op-ed. It's very real, and the same thing about the one Anya mentioned earlier, where a guy was sitting with his hands up and got bit by a dog, and the court said the case you cited where the guy was laying down and got bit by a dog is totally different. So
meaningfully different, right?
So it's qualified immunity for the officers.
That's incredible. Well, okay, so if I could summarize the two things that, because I think awareness of this issue is really, we're in the awareness stage as we have been for 200 years now, that racism is running rampant through, law enforcement in America. But the next level of awareness is kind of understanding the underlying problems here. So Anya, you outlined that ij.org is really helpful. You mentioned an author whose name I didn't quite get, but we'll make sure.
Mike knows him.
Yep,
we'll make sure to get that in the show notes.
I'm into him for a few
This book is much cheaper. Closing the Courthouse Doors. Much cheaper. It's not a treatise. It's not a law book.
Perfect. And then Patrick, I think where I so rudely interrupted you was basically saying, I think to amplify the message, sharing your article is a big part of it, sharing a lot of the stuff from your website. Were you going to say a little bit more about that?
No, I mean, I think it's doing those things, but it's also, once you've internalized this, like, about qualified immunity, and it's not just two random words that shut your brain off. Tell your friends, tell your family about this, and make sure that you're able to explain it in such a way that they understand it, because this is something that's real, and nearly everyone who hears about it will be righteously upset about it, because it's at its core totally ahistorical and totally anti-constitutional, and not something that you'd expect to be happening in the United States of America ever, let alone now.
And especially in light of the situation with Minneapolis Police Department and George Floyd, if this doctrine goes away, you are giving the family of George Floyd another tool in their toolkit to hold the officer accountable and the Minneapolis Police Department accountable.
Yeah.
And to get remedy for the violation of his constitutional right.
Right.
Yeah. And with that, I just want to let IJ know that they are free to use the sandwich artist analogy in full commercial use in perpetuity. And this is recording out on the internet. So if you're struggling with understanding it, if you're struggling understanding it or explaining it to that family member whose brain would shut off, maybe the subway story will help a little bit. Or I was thinking, as we're kind of talking about this, how if we could also apply an analogous situation to Carol Baskin taking over the Tiger King. I don't know if you heard, but Carol Baskin now actually has ownership of Joe Exotic's Tiger Kingdom or whatever. So we'll work on that because I think that story could get shared.
Lou,
you really got to work that up. I'm not quite sure how that all fits together with QI just yet, but
Lou, as your attorney, I insist on following up with the scope of that permission via writing after this is over. So.
All right, we'll follow it up with that. Yeah. Go ahead, Mike.
I think we're closing, but this was just awesome, you guys. Thank you so much on behalf of the Lounatics. I was able to find my bar card, and you guys are inspiring me to maybe want to use it, which is not a feeling I've had since law school. So thank you.
Thanks for having us. It's been great fun.
Yeah, and hopefully, you know, it probably will make sense to have you both back at some point too to get updates on James King and the other stories. You know, hopefully James King's story isn't another 9 years out, but how it applies to everything.
I will say, if you're going to link to the James King case from our website, which is Brownback versus King on the case, we link to a YouTube video where James kind of tells the story in his own words that I think is very moving and would interest people in these topics from a human perspective.
And that was the last thing that I wanted to add in terms of bringing a little bit of more awareness to this issue, is that I think these stories speak volumes, even if you don't fully understand qualified immunity. If you just know that it exists and you know that the stories are out there that protect them, that should be enough to raise awareness of the issue so that the, you know, hardworking, well-educated, you know, passionate people like Patrick and Anya here can do their hard work to protect you from riding your bike down the, you know, down the street and suddenly being actually misunderstood or misidentified as some, you know, fugitive from the law and end up in James King's exact situation, regardless of the color of your skin. I really hope you can help spread this message through storytelling, even if qualified immunity, the concept itself, escapes you. So a million thank yous to all the hard work that you're doing for all American citizens everywhere. And if this is a little bit we can do to help move the message forward, I feel like it's the least we can do. I'm not going to go to law school, but Mike did, and we'll try to work on it and help. So thanks again, awesome. Anya, Patrick. IJ.org is the site. We're going to have a ton of links in the show notes. And this has been, oh, there we go.
That's James King.
That's James.
That's James. Nice. Perfect. Well, thanks to all the Lounatics for tuning in to the most lawful hour. Emphasis on that L. I don't want to, there's an L at the beginning of that, of Hot Lou Happy Hour. I am your host, Hot Lou.
I am qualifiedly going to go back to law school, Mike Franklin.
And we'll talk to you tomorrow.